Hello everyone. Let's continue with vicarious liability. Begin moving further. Servant and independent contractor. A servant and independent contractor are both employed to do same work for of the employer, but there is a difference in the legal relationship which the employer has with them. A servant is engaged under a contract of services, whereas an independent contractor is engaged under a contract for services. The liability of the employer for the wrongs committed by his servant is more onerous than his liability in respect of wrongs committed by an independent contractor. If a servant does a wrongful act in the course of his employment, the master is liable for it. The servant, of course, is also liable. The wrongful act of the servant is deemed to be the act of the master as well. The doctrine of liability of the master for act of his servant is based on the maximum respondeat superior, which means that let the principal be liable, and it puts the master in the same position as he if had done the act himself. It also derives validity from the maxim qui facet per alium facet per se, which means he who does an act through another is deemed in law to do it himself. Since for the wrongful done by the servant, the master can also be made liable vicariously. The plaintiff has a choice to bring an action against either or both of them. Their liability is joint and several, as they are considered to be joint tortfeasors. The reason for the maximum respondeat superior seems to be the better position of the master to meet the claim because of his larger pocket and also ability to pass on the burden of liability through insurance. The liability arises even though the servant acted against the express instruction and for no benefit of his master. For the liability of the master to arise, the following two essentials are to be present. First, the tort was committed by the servant. Second, the servant committed the tort in the course of his employment. A servant is a person employed by another to do work under the direction and control of his master. As a general rule, master is liable for the tort of his servant, but he is not liable for the tort of an independent contractor. Therefore, it becomes essential to distinguish between the two. A servant is an agent who is subject to the control and supervision of his employer. Regarding the manner in which the work is to be done, an independent contractor is not subject to any such control. He undertakes to do certain work, and regarding the manner in which the work is to be done, he is own master and exercises his own discretion. An independent contractor is one who undertakes to produce a given result, but so that the actual exclusion of the work he is not under the order of control of the person for whom he does it, and may use his own direction, things not specified beforehand. So that's it for the guys.